We're back together again with psychological depth. Today's episode will dive into the topic, women are panicking over the new child support rules. The comment section erupted before the legislation even passed. Women who'd never shown interest in family law suddenly became constitutional scholars. Women who'd dismissed men's complaints about the system for years suddenly discovered urgent concern about the children. The framing shifted overnight. Gartham, he should pay what he owes, to they're trying to starve our kids. The panic was visible. The panic was informative. Something had changed. Not completely, not everywhere, but enough that the people who'd benefited most from existing arrangements recognized their arrangements were facing scrutiny they'd avoided for decades. The laws being proposed, the enforcement mechanisms being discussed, the cultural conversation shifting beneath their feet, all of it suggested that the comfortable assumptions underlying child support as practiced might not survive contact with legislators who'd started listening to different constituents. The response wasn't reasoned analysis of what the changes might mean. The response was alarm, accusations, claims that men seeking reform were deadbeats trying to abandon their children. The intensity of the reaction revealed the stakes involved. When systems face reform, the beneficiaries of those systems rarely respond with measured consideration of whether reform might be warranted. They respond with defense of what they've been receiving. Today, we're examining what's actually happening with child support legislation, why the reactions have been so intense, and what the changes might mean for the dynamics between parents, between genders, and most importantly, for the children these systems supposedly serve. The existing system operates on assumptions worth examining. Child support, as currently structured, presumes several things: that the custodial parent, usually the mother, will use support payments for the child's benefit; that the non-custodial parent, usually the father, should pay regardless of how much access to the child he receives; that courts can accurately assess what a child needs and what a parent can provide; that enforcement mechanisms targeting non-payers serve children's interests. Each presumption contains reasonable and problematic elements. The reasonable: children need support. Both parents bear responsibility. Some mechanism for ensuring support is necessary. The problematic: no verification that support reaches children. Payment obligations disconnected from access rights. Enforcement that can destroy men financially while children see no benefit. The disconnect between payment and benefit creates perverse incentives. The mother receiving support has no obligation to demonstrate how the money gets spent. The payment could fund the child's needs, education, healthcare, activities. It could also fund the mother's lifestyle while the child's needs go unmet. The system trusts that the former occurs without mechanisms ensuring it does. Men have complained about this for years. Their complaints were dismissed as attempts to avoid responsibility, as bitterness from failed relationships, as unwillingness to support children they'd helped create. The framing positioned any criticism of the system as moral failure by the critic rather than potential flaw in the system being criticized. But the complaints contained patterns that were hard to dismiss entirely. Men paying substantial support while their children wore worn clothes and attended underfunded activities. Men watching their payments fund vacations, vehicles, and lifestyle upgrades for ex-partners while being told they weren't paying enough. Men who wanted to provide directly for their children being told direct provision didn't count, only the payment to the mother counted. The system as structured serves certain interests more than others. It serves the custodial parent's interest in receiving funds without accountability. It serves the state's interest in ensuring children don't require public assistance. It serves attorneys' interest in endless disputes over payment amounts. What it doesn't clearly serve is the child's interest in receiving actual support from both parents in ways that improve the child's life. New legislation emerging in various states addresses some of these disconnects. Texas introduced what's being called a three-strike system for custody interference. The non-custodial parent denied access despite court orders now has enforcement mechanism with escalating consequences.
First violation brings fines. Second brings increased fines. Third can bring jail time for the parent doing the interfering. This seems straightforward. Court orders should be followed. If a father has been granted custody time and the mother prevents that time, consequences should follow. The mechanism simply creates consequences that didn't effectively exist before. The reaction from some women was revealing. Not, of course, court orders should be followed. Not, both parents should respect custody arrangements. Instead, alarm that fathers might have recourse when denied access to their children. The implication was that mothers should retain unilateral authority to decide when fathers see their children, regardless of what courts determined. The panic exposes underlying assumptions. Some women have operated as though custody arrangements are suggestions they're entitled to override. Some have used access to children as leverage. Comply with my demands or you don't see your kids. Some have assumed that courts will issue orders but never meaningfully enforce them against mothers. The new legislation threatens these assumptions. Custody interference has been endemic. The father who drives hours for his weekend only to find the mother has taken the children somewhere else. The father who's told the children are sick, busy, don't want to see him, repeatedly, suspiciously. The father whose scheduled time consistently gets sabotaged through emergencies that somehow never materialize when custody isn't at stake. Courts have technically had authority to address this. In practice, enforcement was rare. The father complaining about denied access faced skepticism. Maybe he did something to cause it. Maybe the children really don't want to see him. Maybe the mother has valid concerns she hasn't articulated. The benefit of the doubt flowed one direction consistently. The new enforcement mechanisms shift this. The mother who interferes now faces actual consequences rather than theoretical ones. The panic of interference becomes documented with escalating penalties that make continuation risky. The father gains leverage he didn't possess before. Not leverage to harm the mother, but leverage to see his children as the court determined he should. Some proposed legislation goes further. Discussion of making child support voluntary in certain circumstances, ending mandatory alimony, restructuring the entire framework through which post-relationship financial obligations operate. These proposals generate the most intense reaction. The suggestion that child support might become voluntary, that a father might have choice in whether and how much he pays, threatens financial structures many women have built their post-relationship lives around. The panic is economic as much as ideological. Examine the voluntary support concept carefully. It doesn't propose that children should go unsupported. It proposes that support might flow through different mechanisms. Direct provision rather than payment to the mother. Trust arrangements that ensure money reaches children. Structures that maintain support while introducing accountability that current systems lack. The objections often skip these nuances. They want to let men abandon their children. The framing is absolute. Voluntary means zero. The possibility that voluntary might mean differently structured rather than absent doesn't enter the conversation. The panic requires existential framing to justify its intensity. Alimony reform generates similar reaction. The historical rationale for alimony made sense when women rarely worked, had limited ability to support themselves post-divorce, and had sacrificed career development for marriage. Support during transition back to independence served legitimate purpose. The contemporary landscape differs. Most women work. Most women have independent income. The traditional rationale applies to shrinking percentage of divorces. Yet alimony often continues as though nothing has changed, as though the woman who earned independently throughout marriage suddenly becomes unable to support herself upon divorce. Proposed reforms typically distinguish between situations. Long marriages where genuine career sacrifice occurred might warrant continued support. Brief marriages where both parties worked might not. The reforms introduce assessment that the current system often skips. The family court system itself faces growing criticism that crosses ideological lines. The financial extraction that both parties experience, the adversarial structure that rewards conflict over resolution, the unpredictability that makes outcomes feel arbitrary, the years of proceedings that drain resources better spent on children. Men have borne particular burden within this system. The assumption of maternal preference that influences custody outcomes, the income imputation that bases support on what men could theoretically earn rather than what they actually earn, the enforcement mechanisms that can destroy credit, revoke licenses, and leaven, the unpredictability that makes outcomes feel arbitrary, the years of proceedings that drain resources better spent on children. Men have borne particular burden within this system. The assumption of maternal preference that influences custody outcomes, the income imputation that bases support on what men could theoretically earn rather than what they actually earn, the enforcement mechanisms that can destroy credit, revoke licenses, and jail men who fall behind, while equivalent enforcement against mothers who violate custody orders barely exists. The criticism isn't that fathers shouldn't support their children. The criticism is that the system designed to ensure support has features that serve other interests while claiming to serve children.
The intermediation of the mother, making her the recipient of support rather than the child, creates dynamics that may not benefit the child the support supposedly serves. Financial management becomes critical for anyone navigating these systems. Men paying child support need to understand that payments should be documented meticulously, that direct provision might not count against support obligations even when it benefits the child more directly, that the system tracks payments, not outcomes for children. Some men have adopted strategies that work within the system's constraints, paying substantial amounts upfront to avoid ongoing disputes, structuring payments to minimize conflict and maximize predictability, creating trust arrangements that protect both the obligation to support and the resources that provide support. The example of public figures paying large upfront settlements illustrates this approach. Rather than years of contested payments, disputed amounts, and enforced collections, a single payment that settles the obligation. The mother receives substantial resources. The father avoids ongoing exposure to a system that treats him as presumptive deadbeat. The child's financial needs are addressed without continuous conflict. This approach isn't available to most men. The resources for substantial upfront payment don't exist. They remain in the system's ongoing mechanisms, subject to its biases and enforcement patterns. The strategies available to the wealthy don't translate to those with ordinary resources. The gender dynamics underlying these debates reveal tensions the culture hasn't resolved. Some women view child support as entitlement rather than support mechanism. The man who fathered a child owes a debt that extends beyond the child's needs. He owes a lifestyle to the mother. He owes compensation for whatever opportunities she might have lost. He owes acknowledgement that his resources are partly hers by right. Some men view child support as extraction scheme. The system that claims to serve children actually serves the mother's interest, while children may or may not benefit. The enforcement mechanisms aren't about children. They're about ensuring payments continue regardless of what the payments actually accomplish. Both framings contain elements of truth and elements of distortion. Child support that actually reaches children and improves their lives serves genuine purpose. The father who resents this support is resenting something legitimate. But child support that funds maternal lifestyle while children's needs go unmet deserves criticism. The mother who defends this arrangement is defending something indefensible. The children themselves occupy a strange position in these debates, invoked constantly as justification, actually centered rarely. The discussions about what's best for children often reveal more about adult interests than genuine concern for child welfare. What do children actually need? Both parents involved in their lives. Financial resources that reach them rather than being intercepted. Stability that continuous parental conflict prevents. Models of adult behavior that cooperation would provide better than warfare. The current system frequently undermines these needs. The father alienated through custody interference becomes the absent father. Children suffer from lacking. The support payments that fund maternal lifestyle while children's needs go unmet don't serve children. The conflict that the adversarial system incentivizes damages children more than either parent's victory could benefit them. Reform that actually centered children would look different from what either side typically advocates. It would ensure both parents have meaningful access unless genuine safety concerns exist. It would verify that support reaches children rather than trusting that it does. It would minimize conflict rather than incentivizing it. It would recognize that children need parents, not just payments. The panic over new rules often ignores these child-centered considerations. The objections focus on what mothers might lose: income control, unilateral authority. The children whose interests supposedly drive the discussion fade into rhetorical device rather than actual concern. Some women have built entire post-relationship structures around support systems. The child support that constitutes primary income, the lifestyle that support enables, the arrangements that depend on continuation of current levels without accountability for how levels translate to child benefit. These structures face examination.
They've avoided the questions that weren't asked before. What happens to the money? Does the child actually benefit? Is the amount appropriate to the child's needs or inflated beyond them? These questions now have legislative backing that makes them harder to dismiss. The arguments against reform often reveal what's actually being defended. I sacrificed my career for him. Perhaps true, perhaps deserving of consideration, but separate from what the child needs. I can't support myself alone. Perhaps true, but the child support system isn't unemployment insurance. He should pay because he left. Vindictive rather than child-focused, revealing the actual dynamic operating. Some situations genuinely warrant significant support. The mother who genuinely sacrificed earning capacity during marriage. The child with special needs requiring resources beyond ordinary provision. The circumstances where the child's well-being genuinely requires the support amounts being paid. These situations exist and deserve accommodation in any reformed system. But these situations don't describe every child support arrangement. The system that treats every case as though it resembles the hardest cases produces outcomes that don't match most actual circumstances. The reform conversation involves calibrating response to circumstance rather than defaulting to maximum extraction. Paternity issues add further complication. Men paying support for children who aren't biologically theirs. The systems that establish paternity through process rather than biology then enforce payment obligations regardless of subsequent evidence. The men who discover non-paternity years into payment but find obligations continuing anyway. These cases generate particular outrage. The fundamental unfairness, paying for a child that isn't yours, that resulted from another man's relationship with the mother, seems impossible to justify. Yet the system frequently justifies it through arguments about the child's established expectations, about the man's previous willingness to pay, about the impossibility of recovering from actual biological father. The child in these situations genuinely faces difficult circumstances. The support they've received may not continue if biological truth determines payment obligations. The stability they've known may be disrupted by circumstances they didn't create. Their interests deserve consideration even while the man paying for a child that isn't even his faces genuine injustice. Reform proposals that address paternity issues try to balance these concerns, establishing clearer paternity verification before obligations attach, creating mechanisms for addressing non-paternity discovery, ensuring that children's needs are considered while not indefinitely obligating men to fund children who aren't theirs. The reactions to these proposals follow predictable patterns. Some women defend the status quo absolutely. Once established, obligations should continue regardless of biological truth. Some men demand immediate termination of obligations upon non-paternity discovery, regardless of child impact. Neither extreme engages seriously with the genuine complexity involved. The societal assumptions underlying child support deserve examination too. The presumption that mothers provide care while fathers provide money reflects dated understanding of parental roles. Many fathers want to provide care directly. Many are capable of doing so. The system that channels their contribution through payment rather than presence may not serve children as well as more balanced arrangement. Shared custody arrangements that divide time equally are becoming more common. In these arrangements, both parents provide direct care. Both provide financial support through their direct provision. The child support system designed around primary custodial models fits awkwardly with arrangements where neither parent is primary. The reforms being discussed include recognition of these changed arrangements, support calculations that reflect actual custody division, mechanisms that acknowledge direct provision of support rather than requiring additional payment, systems that adapt to contemporary parenting rather than presuming maternal custody with paternal payment. Public reaction to reform proposals correlates interestingly with stake in current system. Women receiving support tend to oppose reform. Women paying support, a minority but existing, tend to support reform. Men paying support tend to support reform. Men receiving support, rare but existing, have mixed reactions.
The positions correlate with interest more than principle. This isn't surprising. Self-interest shapes political positions generally, but the acknowledgement clarifies the debate. The woman arguing against reform because her children will suffer might genuinely worry about her children. She also might worry about her income. Separating these concerns helps evaluate the arguments being made. Children's welfare and custodial parents' income are not identical. Sometimes they align. More resources for the household can mean more resources for children. Sometimes they diverge. Resources to the parent don't reach the child. The current system presumes alignment without verifying it. Reform proposals often introduce verification mechanisms that distinguish genuine child benefit from parental enrichment. The enforcement mechanisms have been dramatically asymmetric. The father who fails to pay faces wage garnishment, license revocation, potential imprisonment. The mother who interferes with custody faces usually nothing. The Texas legislation begins addressing this asymmetry. Both parents should face consequences for violating court orders. The system shouldn't enforce against only one gender. Resistance to enforcement symmetry reveals underlying beliefs. The mother who opposes consequences for custody interference believes she should retain authority to override court orders without penalty. The belief isn't usually stated this directly. It's wrapped in concern about dangerous fathers, about children's preferences, about circumstances the court didn't understand. But reduced to essence, the belief is that her authority should exceed the court's authority when she deems it appropriate. Courts exist precisely because parties to disputes can't be trusted to resolve disputes fairly themselves. The mother who believes she should override custody orders believes she's the appropriate decision-maker rather than the court, given that she's interested party to the dispute. This belief is self-serving, even when sincerely held. The acrimonious panic reveals what was always operating beneath the surface. The system that appeared to be about children was partly about children and partly about financial arrangements between parents that children justified but didn't necessarily benefit from. The reform proposals threaten the second element while claiming to preserve or improve the first. Some panic is performative, the exaggerated alarm that social media rewards. The absolutist claims that engagement algorithms prefer over nuanced analysis. The positioning as defender of children that provides moral high ground regardless of whether children's interests actually motivate the position. Some panic is genuine. Women who've structured their lives around support that might change. Women who genuinely worry about providing for children if support arrangements shift. Women facing uncertainty about systems they'd understood and built around. Genuine anxiety exists alongside strategic panic. The distinction matters for response. The strategic panic can be countered with accurate information about what reforms actually propose. The genuine anxiety deserves acknowledgement alongside explanation that reforms typically include transition provisions, that existing obligations often remain, that children's welfare genuinely concerns reformers as much as it concerns those defending current systems. What might actually happen as reforms proceed? Gradual shift toward enforcement symmetry, increasing requirement for accountability in how support is used, movement toward arrangements that reflect actual custody rather than presumed custody, greater emphasis on direct provision alongside or instead of payments, paternity verification before obligations attach. None of these changes means abandoning children. All of them mean adjusting systems that have operated without significant scrutiny toward arrangements that serve children's interests more genuinely. The panic framing reforms as abandonment misrepresents what's actually proposed. Both parents bear responsibility for children they create together. This principle isn't under attack. What's under attack is the specific mechanism through which responsibility has been enforced. Mechanisms that may have served one parent's interests more than the child's, that may have extracted resources without delivering benefit, that may have enabled abuse of process while claiming to prevent abuse of children. Reform doesn't mean perfection. The systems that emerge from reform will have their own flaws. The criticism that current systems receive might someday apply to their successors.
The process of adjustment continues indefinitely because no system perfectly serves all legitimate interests. For men navigating current systems while reform proceeds, practical considerations apply. Document everything. Comply with orders even while challenging them. Understand that current systems still govern until reform actually changes them. Prepare for reform to take years, even when movement seems to be happening. For women navigating these changes, practical considerations apply too. Don't assume current arrangements will continue indefinitely. Don't structure lifestyle around support levels that might change. Don't assume that resistance to reform will prevent it. The energy spent panicking might be better spent planning for different arrangements. For children who don't choose these situations, don't understand the adult conflicts, and bear consequences regardless of which parent prevails, the hope is that reform serves them better than current systems do, that both parents remain involved, that resources reach them rather than being intercepted, that stability replaces conflict, that they grow up knowing both parents rather than being weaponized in disputes between them. The panic will continue as legislation proceeds. The debates will intensify as proposals become law. The adjustment will take years as new systems replace old ones. Through all of it, the question that should guide evaluation remains: what actually serves children's interests? The answers might differ from what any participant in the debate assumes. The reforms might serve children better than current systems. They might serve them worse. They might serve some children better and others worse. The complexity that genuine concern for children would acknowledge gets lost in panic that's often more about adult interests than child welfare. The new rules aren't about punishing women or rewarding men. They're about recalibrating systems that developed under different circumstances and produced outcomes that don't match their stated purpose. The recalibration might succeed or fail. It deserves evaluation rather than panic. The panic reveals what's actually at stake for those panicking. When someone reacts to accountability mechanisms with alarm, consider what the accountability might reveal. When someone opposes verification of how money is spent, consider why verification threatens them. The reaction often tells you more than the arguments the reaction produces. Systems serve those they're designed to serve. The child support system, as currently structured, serves certain interests clearly and children's interests ambiguously. Reform proposals attempt to shift that balance. Whether they succeed depends on implementation details that panic prevents examining clearly. 3 children deserve better than to be invoked rhetorically while their actual interests receive secondary consideration. The reforms being proposed and the reactions they're generating both deserve evaluation against what would actually serve children, not what serves parents who claim to speak for children while serving themselves. The rules are changing. The panic is real. What happens next depends on whether the conversation can move past panic toward genuine consideration of what these systems should accomplish, and whether proposed changes move toward or away from accomplishing it. The children watching their parents fight over money and access will grow up shaped by what they witness. The system that governs their childhood influences who they become. Getting that system right matters more than which parent wins the current round of legislative debate. Better systems serve everyone, children most of all, but parents too. The conflict the current system incentivizes serves no one except those who profit from conflict. The reform that reduces conflict while ensuring genuine support serves everyone the system should serve. The panic will fade as the new becomes normal. What remains is whether the new actually improves on the old. That determination requires examination that panic prevents. When the panic subsides, the actual evaluation can begin. So, what are your thoughts on today's topic? Make sure to like this video and subscribe to our channel Psychological Depth so you won't miss any of our upcoming posts. Thanks for tuning in. See you next time.